Hello, everybody. My name is TJ Scott with the Law Office of Timothy J. Scott. I can be found online at tjslawoffice.com. I'm an estate planning attorney, and so one question I often get is what is estate planning and why do people plan their estates? Well, at its essence, estate planning is putting things in place for your family and friends for when something happens to you, meaning incapacity or death. Doesn't necessarily mean a will. That's what a lot of people think about when they think estate planning. But that's in the realm of what we're doing. We're talking about incapacity and death. We are all going to die. It's an unfortunate but true statement. We are all going to die, and some of us will become incapacitated before we die. Incapacity can happen when you're in a coma, or it can happen from something like dementia or Alzheimer's, where you are in a position where you can no longer decide, you can no longer make decisions for yourself. If you don't have a plan in place and you become incapacitated or for when you die, the state has written a plan for you, and that plan involves court. In the case of incapacity, there are court cases to determine who can make financial decisions for you and who can make healthcare decisions for you. Oftentimes, the people that the court would choose to make those decisions for us are not the people that we would choose to make those decisions. And because they're not the people that we would choose to make the decisions, and because they don't have great guidance about what we would want, oftentimes they are making decisions that are not the decisions we would want to have made on our behalf. In the case of death, there's another court case called Probate. And in probate, the court appoints a representative to act on behalf of our estate. That's a person who collects our assets, inventories our assets, and then distributes them out to pay creditors and the people who will ultimately receive. And who can receive from your estate? Well, if you don't have a plan in place, the state of Minnesota has written a plan for you. They've written a plan in the statutes called the intestacy statutes, and they've done their best job to determine who they think you would want to receive your assets. But again, as you can imagine, it might not actually match what you want to have happen. If you have minor kids and you become incapacitated or you die, those kids will need someone to raise them until the age of 18. In that case, there's another court case special for that purpose called guardianship. And in guardianship, the court determines who in their judgment would be the best person or people to raise your kids until the age of 18. As you can imagine, the person or people that the court might choose for that job might not be the person or people that you would choose for that job. You know your kids a lot better than any court can get to know your kids, and you know where your kids would flourish and where they would not thrive. So, it's probably no surprise when I tell you that all of these court cases are expensive. They are time and energy consuming for your family and friends, and even worse, they can lead to a ton of conflict between your family and friends. Lead to breakdowns in family relationships and between friends. Here's something you might not know. These court processes are also optional. With an estate plan, you can take control. As an estate planning attorney, it's my job to empower my clients to make and document the decisions that my clients want made in the case they become incapacitated or for when they eventually die. If you're interested in taking control and making decisions so that your family and friends are well cared for when something happens to you, please reach out to me. Again, my name is TJ Scott with the Law Office of Timothy J. Scott, and I can be found online at tjslawoffice.com. I hope to hear from you soon.